Welcome to Self-Defense Law 101. 101 implies a 102, 3, 4, which is in the planning. This one is a very brief introduction for basic self-defense law considerations. I am Burton James Jimmy Brown. I go by Jimmy, so use that. Disclaimer right off the top. What I'm doing here does not constitute legal advice, and it wouldn't hold up in court if you tried to say that it was. This is educational only. Legal advice, as you can see here on the slide, forms an agreement between an attorney and yourself or any client, implying an actual legal need and the attorney's solution or research into that need. That's legal advice. This is educational. Two kinds of law, and they're often confused: gun law and what we're doing here today, self-defense law. Gun law is mostly about buying and selling and transporting weapons, and within your particular state, also acquiring and qualifying for your concealed carry permit. That's gun law. Self-defense law is about the requirements involved if you have to defend yourself in an actual defensive threat situation. And we're mostly thinking about having to take lethal force, but it's also non-lethal force. What can and can you not do if you are threatened? That's self-defense law. Self-defense law is comprised of actually three components. You've got statutes, jury instructions, case law. Statutes come in statute books. The legislature of each state does general laws in session. Those are done in order, and then those that are committed to the statute book are moved to it and given the proper chapter and subsection code. We're dealing here, obviously, with self-defense statutes in whatever your state might happen to be. Remember, and this is very important, there are 5 elements to self-defense law. Innocence. You must be innocent. You cannot be the one that started the fight. We'll talk a little bit more about a kind of exception to that, but don't think of it that way. Think of it as I must be innocent. Imminence. It can't be a phoned-in threat where a guy's going to shoot you in your front yard tomorrow. You can't then track that person down and shoot him first. The threat must be right now. It must be imminent. More about that later. Proportionality simply means that the force that you respond with has to be proportional to the threat that you're receiving. If somebody comes in and shoves you to the ground, you can't shoot him. Best advice would be get up and leave. Don't get in a fight to begin with, and you don't ever have to worry much about self-defense law. However, that isn't always possible. Avoidance. Here in Florida, we have no duty to retreat, which is actually the appropriate legal language, duty to retreat. Some states have a duty to retreat. We call this here, with no duty to retreat, stand your ground. Florida, Georgia, South Carolina, who only became so about 2009. And reasonableness, that's the umbrella for which the other 4 fall under. Everything that you do must be reasonable. Self-defense law, again, is comprised of statutes, which I've already described. Chapter 776 in Florida is the justifiable use of force. Georgia also has Article 2, justification and excuse, in Section 16-3-2. It's basically the same set of law just for Georgia. Jury instructions, not technically law in and of themselves, but where states have what they call pattern jury instructions. They have pattern jury instructions for almost anything that you can pull out of the statute book. The motive behind it is that when the judge charges the jury, when they go off to reach a verdict, they will be given those instructions. And it takes a statute and breaks it down into common language in what's supposed to be a much simpler form. In practice, it doesn't always seem that way. But because of jury instructions, and for maybe a self-defense law 102 or 103, jury instructions come up in appellate cases a lot. The defense who gets convicted will decide that, hey, this particular instruction should not have been given to the jury. We argued for this one, the judge went for another one, and we got a conviction on us. We don't like that, so they'll make an appeal. And it's not uncommon for the appellate court to send it back for retrial or rehearing on the particular issue. So jury instructions, though not directly law, a sort of restatement of the law, play very strongly in all kinds of, particularly criminal cases, and apply often to self-defense cases. Case law, that's where real law, it's where the rubber meets the road when we're talking about law, any area of law. When an appeal is made, whether it's about a jury instruction or just the illegality of a search, whatever might be the issue under appeal, when the appellate court makes a decision for the jurisdiction that that appellate court covers, that becomes the real law. That becomes what must be done. It affects law enforcement and it affects the courts within that jurisdiction. If that ruling is handed down, let's say by the 5th District Court of Appeals in Florida, every jurisdiction, every county, every city within the 5th District Court of Appeals area must abide by that decision. Like I said, rubber meets the road law is case law. To the 5 elements, innocent. As I mentioned at the top, you must be innocent. You cannot start the fight and expect to be protected by a claim of self-defense. If you lose on this element, in point of fact, if you lose on any of the 5, pretty much lose, period, and likely prison is in your future. Having lost your innocence by starting the fight, is it possible? It's a common question. So we'll hit this right away. Can you regain your innocence? Is that possible? Yes, we're going to talk about that. But don't get into that situation to begin with. Best advice, just personal advice, don't get in the fight and you're not going to have to worry about getting a lawyer. And keep in mind, if you have to use lethal force, defense costs can go tens of thousands, hundreds of thousands of dollars. It could top $1 million to defend yourself against a case like that. It's going to ruin your life probably no matter what. So avoid these. It's certainly going to affect your life in your future, even if you're found innocent. And if you have followed these elements carefully and can show that in court, that should be the outcome. Regaining innocence. So let's use an example that I have here. You get into an altercation at a park, the parking lot of a Walmart, doesn't matter where, your front yard, and you push a guy, and then you grab a baseball bat and decide you're going to hit him over the head with it. You think better, you back up, you throw the bat down, and you turn and leave, and you say, okay, I'm out. We're not doing this. The guy you knocked to the ground, however, and threatened with a bat, he's not done. He gets up with a knife and decides he's going to carve you up a little bit. You back up, realize that you're now under a hardcore lethal threat, lethal or great bodily harm, remember that language. You can't use your firearm in self-defense unless the threat is potentially lethal, meaning it will kill you or somebody that you're protecting, or is likely to cause grievous, great bodily harm. So you shoot this guy when he comes at you with a knife and you kill him. Your problem, you still have a problem because you are guilty in fight number 1. And for legal purposes, think of this as 2 fights. It may have been one overall altercation, but think of it as 2 fights. The first one, you started, you pushed, you made a threat with a baseball bat or an axe handle or whatever else might do some serious damage. You thought better of it and you withdrew from the fight and you did so clearly, and that's also important, you must make sure that that person knows that you are out. So you do actions that show withdrawal from the fight, and you should state, whether you use I'm withdrawing from the fight, or I'm out, or I'm done, I'm leaving, whatever, show clearly that your intention is to disengage from the altercation. You also threaten him with a baseball bat. So when you push the man, that's a simple battery, misdemeanor enough. But when you threaten him with a baseball bat, that's an aggravated assault. You didn't carry out the assault and turn it into an aggravated battery, but you threatened a person with a weapon likely to do some serious damage, potentially even lethal. You withdrew. He comes after you with a deadly weapon, a knife. He's going to carve you up, and you shoot and kill him. You can still be convicted and face prison time, particularly for the aggravated assault portion. You're not off the hook for fight number one. But given the basic facts of this case that I'm expressing to you, you should be off the hook for case number two, the one involving the knife, the threat against your life, and you're having to defend yourself with a firearm. Again, the best policy, don't start the fight in the first place, because at the very least, you have muddied the water of your self-defense claim by being the first aggressor. It does turn the evidentiary requirements for you up a lot if you're the person that started the fight. And keep in mind, if it's a public place, he's going to have witnesses too, he or she. They're going to have witnesses in all likelihood. You hope you have witnesses, and you certainly hope that the physical evidence at the scene backs you up. Keep all this in mind. It's a very dicey business. Don't get involved in the altercation to begin with is the best way to stay out of court. The second element is imminence, as I mentioned at the top. You're facing the threat right now. If it's a non-lethal threat, and remember, self-defense law also covers non-lethal, which means like a fist fight, you can obviously respond and have your fight. Of course, both of you might end up being arrested, but probably for a misdemeanor, unless something aggravates that situation. But if we're talking lethal defense, having to use your firearm, let's break this one down into three sub-elements: ability, opportunity, and jeopardy. Imminence is broken down into these three additional elements: ability, opportunity, and jeopardy. If somebody calls you, I think I mentioned this earlier, on the phone and says they're going to come over to your house tomorrow and shoot you, it's not imminent. That's tomorrow. You've got time to leave town, fly away, call the police, do a lot of things to avoid the potential of getting shot by this individual tomorrow. There's a lot of things that you can do without going and tracking that person down and deciding, well, he said he was going to kill me and I believed him, so I found him at his bar and I shot him. Not going to work. That is not imminent. Imminence, we're continuing. Ability. Does this person who is threatening you have the ability to carry out the threat? If they're right on top of you with a knife, as you can see here in this photograph, then yes, you would have to say, yeah, I'm in trouble here. But if he's 100 yards away with the same knife, kind of saying, yeah, I'm going to cut you up, man. Yeah, I wouldn't shoot yet. You need to be close. You've got a lot of distance, and if you've got places to go to those places. You don't have justification for shooting because you lose on imminence, because the person at 100 yards does not have the ability. On the other hand, if he's got, his bolt action hunting rifle and he's at 100 yards away, yeah. And he said, I'm getting ready to shoot you, and you hear him chamber that rifle, then even at 100 yards, of course, firing your pistol at 100 yards, if that's what you're carrying, look for some place to be, I think, other than find obstacles, put additional distance between you and the threat. But under those circumstances, with a rifle, even at 100 yards, your life is definitely in danger. What factors are considered? Disparity of force falls in here too. This is an interesting one because, and this comes up in the case law. Disparity of force. What does that mean? You're one person seat belted in the front seat of your car. Think of the recent mob violence, and they've broken your window or you had it down to begin with, and you're being hit, and there's 6 or 8 of them. So you draw and you fire. Superior numbers. Frequently with women, physical differences are a thing. If you've got a big MMA fighter who's 6'5" and weighs 250 pounds, and there's a 5'2" woman, or even a small man, that guy obviously is in a position to put a hurting on you. Disparity of force. Male versus female, as a general rule. The cases will show an exception to that every now and then. Youth versus elderly. As I get older, I'd like to rely on that a little bit more, but it also depends on the elderly person. How able are they, and were they in a good position to defend themselves? Or perhaps were they trained in defending themselves? If that can be shown. He could use he's 68 years old, but he can do jujitsu, then maybe he should do the jujitsu and not shoot somebody. Able versus disabled there. Positions of disadvantage, I mentioned one already. If you're seat belted into your car, your ability to maneuver, move, avoid trouble is highly restricted. The other thing is a very highly skilled attacker, such as the MMA fighter. But as a rule, a general rule, you have to know that they are at the time of the attack. You can't sort of back that evidence in later. You can't find out, whoa, he was an MMA fighter, but did you know that? No, I've never seen the guy. You don't want to do that. Disparity of force, you're armed with a handgun, you feel you're forced to use, your attackers are unarmed, but there were 6 of them. A small woman's being attacked by a very big man determined to beat her badly. You're stuck, seat belted in your car while the aggressor is beating you in the head. These are disparity of force examples. Really hit them on the previous slide when we were listing them. The specific facts, and this is about facts and evidence. If you're going to claim self-defense and disparity of force because you felt you had to shoot someone, then these factors are going to have to be spelled out. You're going to have to be able to back them up. You're going to have to be able to produce the evidence to back these things up. Opportunity. Remember, ability, opportunity, and jeopardy, the 3 sub-elements of imminence. Does the person posing the threat have the opportunity to carry out the threat? Proximity and obstacles is the big thing. Are they close, and are there obstacles that you can use? You have somebody threatening you with a knife, trying to rob you in a parking garage. Is there an easy place that you can put something, a concrete pillar or something like you can put between yourself and the man while you show him perhaps that you mean business too? But proximity, obstacles, and distance are very, very key in opportunity. I like this slide, by the way, with you've got the knife, that's obvious. It could also be a gun. Darkness, darkness is not by itself opportunity, because the person threatening you could still be a good distance away. He could be hollering from the 2nd floor and you're on the 1st floor. I'm going to come down there and get you. If it's a parking garage, get in your car and leave. That is not opportunity. So keep in mind, opportunity is not by itself, darkness does not by itself encompass opportunity, but it's certainly part of the evidence that you would show later if in fact you ended up being charged with a self-defense related crime. The third of AOJ, ability, opportunity, jeopardy, is jeopardy. Does the threat place you in imminent jeopardy? These 2 slides on the left and the right, this looks like imminent jeopardy. One guy's already on the ground being kicked and beaten. The other guy is cowering, holding a notebook or something up in front of his face, in front of a guy who appears to be there to do him harm. Those slides show this is about to happen. Both of these guys, the one on the ground and the one cowering up against the wall, it would seem to me that they are facing actual jeopardy. And the young lady in the middle one, she's expressing fear. If the threat places you in immediate fear of death or great bodily harm, again, determined largely by distance and obstacles, there's a threat. If there's a wall, a hedge, a row of cars between you, you might not be in immediate jeopardy, and the facts of the case will have to unfold. Get out of Dodge as best you can. Element number 3 of the original 5 elements is proportionality. In this context, we're asking you to respond with an appropriate amount of response. If it's a fist fight, don't shoot. If somebody pushes you on the ground, don't shoot. We had a case in Jacksonville, I think just a couple of years ago, where a guy got pushed on the ground by a younger, bigger guy, but that's all. There was no additional movement to kick him or anything like that. And he shot and killed the young man. That made the papers here in Florida a bunch. That was not a proportional response to the threat. As mentioned earlier, self-defense can be either non-deadly or deadly. If you're facing non-deadly force, you may not respond with deadly force. Remember, if the guy in the parking lot threatens to punch you, pulling out your pistol is not an appropriate response to that threat. Proportionality. Avoidance. In the state of Florida, we are, as mentioned earlier, stand your ground. We're a stand your ground state, which is the common term that the press loves to use. We are stand your ground, which means that we do not have a duty to retreat. Now, this isn't a get home free card, avoid jail, collect $200. It is, however, it's a wonderful thing to have if you have it in your state. In our corner of the United States, Georgia, Florida, and South Carolina, we do, in point of fact, have no duty to retreat. If you are in a state that has a duty to retreat requirement, you must avoid that conflict. However, no state of the 15 or 16 that do require a duty to retreat, none of them require you to retreat where it is not possible to do so without increasing your risk of injury. If you're backed into a corner, you've got no place to go. In that case, you would not have to retreat. Remember, you simply have no legal duty to retreat, but you might think about it if you can, and that can play later. Even if you're in a stand your ground state, if you had, and it's on video, everything's on video now, if you clearly had something to be behind, some way to get away, and you failed to take it, you know, an overzealous prosecutor could decide to take that to the grand jury and get you indicted and get you tried. And if there is video, let's say, and if it played in trial, imagine how that's going to look to a jury. And you had a place to go. You just simply didn't take advantage of it because in your mind you thought, well, I don't have to. Common sense. Always common sense. If you can get away, do so. Honestly, you don't want to shoot somebody if you don't have to, because that is going to be, even if you're cleared quickly, it's still a hassle in your life. And it could be, and if you do get charged, it could be extraordinarily expensive to defend yourself. Last paragraph there. Every person confronted with a situation like this must make an ethical and moral judgment about trying to avoid the confrontation, if possible. But keep the following in mind. If I have no duty to retreat and I do not retreat, am I completely good to go? I mentioned this a second ago. No, not necessarily. You've got to be, these are important elements here. You've got to be in a place you have a legal right to be. You can't be in the middle of burglarizing somebody's house and decide you're going to shoot this guy because he's threatening to kill you with his shotgun. Your Honor, it was self-defense. Well, no, not actually. You were committing a felony at the time. You have to be where you have a legal right to be. And you must not be engaged in illegal activities. So let's say you are in a place that you legally have a right to be, like the parking lot at the grocery store, because you go there all the time, but you're selling cocaine out of the trunk of your car, and you get it. That is an illegal activity. You cannot sell cocaine out of the trunk of your car down at the grocery store. If you have a clear and avoidable route, and don't take it, the prosecutor might decide to charge you anyway. And then he could paint that picture of you as having acted unreasonably, and that brings us to the last of the 5 elements. The final umbrella is reasonableness. The final element is an umbrella. Everything in elements 1 through 4 falls underneath that umbrella. So think of it that way. If the umbrella covers all 4 previous elements, likely it was reasonable. So keep the umbrella in mind and stay under its coverage. A reasonable person is the standard that they use to decide what's reasonable in court. And that person, he or she, doesn't actually exist. There is no such thing as an actual reasonable human being. To the law, we're all unreasonable. The reasonable person is merely the yardstick to measure whether a person's actions were reasonable under a very specific set of circumstances, the one that you're involved in. The court's definition of a reasonable person is a reasonable, prudent, logical, and cautious person. When the court's definition of a reasonable person is placed in the exact same situation as the defendant, who was involved in the citizen-involved shooting, knowing what the defendant knew at the moment of the altercation, then the court determines what actions a reasonable person would have taken. If, in the judgment of the court, a reasonable man would have acted as the defendant did in those circumstances, knowing what they knew, then he or she would pass the reasonable person test. If not, they could be once again looking at prison time. Remember, and here's our summary, you may not start the fight. The threat you face must be imminent, and your response to that threat must be proportional to the threat itself, the one that you're facing. And duty to retreat states, if you can retreat, you must. If you have no safe avenue of retreat, this element is then not required. And above all, your actions must be judged by the court to be reasonable.